Hello, I'm Susan Im from ImLaw. Today's topic is deferred action for childhood arrivals. Deferred action for childhood arrivals. We are really excited about this topic. This was something that had come about as a result of President Obama's announcement in June of 2012. And really, I want to clarify what is DACA, that's the acronym for Deferred Action for Childhood Arrivals, what it is. It is a 2-year reprieve from removal or deportation with eligibility for employment authorization in most cases for a 2-year period. So it's not a green card, it's not work visa status, it's really not a lawful status of any kind, but it is a 2-year reprieve to be able to remain in the country free from the fear of removal, deportation with employment eligibility. What are the requirements for DACA? There are some very specific, stringent requirements. You must prove that you were under the age of 31 as of June 15th of 2012. You have to prove you came to the United States when you were under the age of 16. You must prove that you have continuously resided in the United States from June 15th of 2007 through the present, so for that 5-year period of time. You must prove you were physically present on June 15th of 2012. So you must not have been outside the country on June 15th of 2012. This is the one situation where you must prove that you entered without inspection before June 15th of 2012, entered without proper documentation, entered illegally, or that your lawful immigration status expired as of June 15th of 2012. Most other benefits in immigration law, this would be a huge strike against you, right? You have to prove that you're in status in order to apply for a work visa status or student visa status. In DACA's case, you actually have to prove that you are without lawful status as of June 15, 2012. You must prove that you are currently in school, have graduated or obtained a certificate of completion from high school, or obtained a GED. You can also satisfy the in-school requirement by proving you were an honorably discharged veteran of the Coast Guard or the Armed Forces. You must not have been convicted of a felony, a significant misdemeanor. We're going to get to what are the actual definitions of those, and 3 or more other types of misdemeanors. You must also prove that you're not otherwise a threat to public safety or national security. And finally, you must prove that you are 15 years of age or older at the time of the filing of the application, unless you are currently in removal proceedings, unless you currently have a final removal order or a voluntary departure order. And you must also prove that you are not in immigration detention at this time. Because if you are in immigration detention, you may be able to apply prior to the age of 15. All right, so identity. There's a lot of different kinds of evidence that you're going to have to gather together if you want to make a DACA application. For proof of identity, it's going to be essential that if you ever possessed a passport, even if it's expired, we're going to want to take a look at it and submit it. Birth certificate with photo ID if you've got it. A school certificate or school ID. That's a really important piece for most of our young DACAs. They're going to have school IDs from when they've been in the United States. If they possess U.S. government immigration documents or a national identity document from your home country, those things would be important to prove identity. To prove that you came here before your 16th birthday, if you entered with inspection, if you entered legally, we're going to want to get copies of your immigration status documents from a long time ago. Maybe that's a Form I-94, which is a document that foreign nationals receive upon arrival to the United States. Maybe it's a passport, even if it's expired, that shows an admission stamp. But let's face it, for most folks, they didn't enter with inspection. So they're going to be looking at providing school records, that shows the U.S. schools that they attended. You're going to be looking at travel records, maybe hospital or medical records, official records from a religious entity, maybe in confirming participation in a baptism or a first communion, any other documents that might be relevant. Proof of immigration status, this goes back to if you did possess immigration status in the past. This might be your Form I-94, the arrival departure record when you first came to the United States. If you were placed in removal proceedings, maybe it's a copy of a final order of removal. Maybe it's a charging document placing you in removal proceedings, or really any relevant document to be able to show that as of June 15th, 2012, you possessed no status or that your status had expired. To be able to prove that you were physically present on June 15th, 2012, this can be a little tricky because even folks that are U.S. citizens might have a hard time digging up something that proves they were actually in the United States on June 15th. But if we take a little look at prior immigration history and some of the lessons learned in other passages of law, we can collect from that. We can collect some ideas and think about whether you can show evidence that maybe it was a little bit before June 15th. Maybe it was June 14th or June 13th that you made cell phone calls that can be tied to you. So cell phone bills, Facebook posts, maybe it's credit card statements showing you made some transactions, purchased things on June 15th, school records that verify that on June 15th you were enrolled in school, military records, religious records, rent receipts, utility bills, any of these sorts of things. If there are phone texts, bills that really just evidence your presence here in the United States and your activity in the United States on June 15th. Proof that you continuously reside in the United States since June 15th of 2007. This is all about showing your continuous residence. So if you never left the United States, even for a brief departure or trip, hopefully you've got school records. Maybe you have employment records, W-2 forms, pay stubs. Maybe you have rent receipts, utility bills, cell phone bills, credit card statements, religious ceremony, baptism certificates, marriage certificates, things like that that show, you have been carrying on a life here in the United States from June 15th, 2007 through the present. Proof of your student status at the time of requesting DACA. This is an easy one. School records, report cards, transcripts, letters from the school that verify your attendance. Those are really good things. High school diploma if you graduated, or certificate of completion from that high school. GED certificate. These would all be the things to prove you're in school at this time or that you've graduated from school. If you did leave the country, it's going to be important to be able to prove that your absence from the United States was brief, casual, and innocent. So if you left the country sometime between June 15th, 2007 through the present, we're going to want to get copies of your plane tickets, your itineraries, your passport stamps, hotel receipts if you were abroad for just a period of time, any other evidence to prove that you only went for a brief, casual, and innocent absence, and that the purpose that you left for was lawful. It wasn't for an unlawful purpose. If you're an honorably discharged veteran of the U.S. Armed Forces, we don't have a lot of these folks out there because oftentimes they're going to be eligible for for actual immigration benefits. DACA may not be their best choice. But if we happen to have an honorably discharged veteran applying for DACA, we're going to want their DD-214 certificate of release or discharge. If you were with the National Guard, we're going to need your report of separation, the NGB Form 22. If you have military personnel or health records, those can be relevant and helpful as well. So again, being able to prove the in-school requirement, this really just to touch on if it was a new school. Let's say you haven't graduated from high school or haven't gotten your GED yet. You're currently in school right now. It's important to state and document what kind of program are you currently in, because DACA does have some strict requirements for eligibility in terms of if it is a school that you're currently enrolled in right now, they want to see that it's one that's providing training or education to lead you to a post-secondary education or a career. So they're going to want to see evidence of that qualifying program, its existence, and other evidence of overall quality. Let's talk a little bit about the criminal guidelines. I did mention at the start of the video that you cannot have been convicted of a felony, a significant misdemeanor, or 3 or more non-significant misdemeanors. What are the definitions of those 3 categories for DACA? Felony is a federal, state, or local criminal offense punishable by imprisonment for a term exceeding 1 year. Exceeding 1 year. Significant misdemeanors are a criminal conviction for an offense which the maximum term of imprisonment is 1 year or less, but greater than 5 days. So that will fall under significant misdemeanor. However, there are other specified offenses that are significant misdemeanors for purposes of DACA, regardless of the maximum term of imprisonment. They are domestic violence convictions, sexual abuse or exploitation, burglary offenses, unlawful possession of a firearm or use of a firearm, drug distribution or trafficking, driving under the influence. This is a really important one to mention, driving under the influence. Sometimes folks are surprised by this, but the Department of Homeland Security takes drinking offenses very seriously, and even if it's a first-time offense for a DUI and it's a 90-day misdemeanor, that might even go away, and after a certain period of time, that is a disqualifier for DACA. The third category of offenses that can disqualify you for DACA are non-significant misdemeanors if you have been convicted of 3 or more non-significant misdemeanors, which are really criminal offenses for which the maximum term of imprisonment is 1 year or less, but still greater than 5 days, and doesn't fall under one of the enumerated categories, as I mentioned, the drinking under the influence, domestic violence, and so on. If you were a juvenile, it's important that juvenile adjudications are generally not going to disqualify you from DACA. However, if you were a juvenile and you were tried and convicted as an adult, you will be treated as an adult for purposes of DACA, and they're going to look at that very carefully. Confidentiality. Often we get the questions, if we come out of the shadows and make a DACA application, who is USCIS going to share my information with? Because I'm concerned about myself getting thrown in removal proceedings. I'm concerned about my relatives getting thrown in removal proceedings. Under what circumstances are they going to share my information with Immigration Customs Enforcement, ICE, those are the folks that put people in removal proceedings, and Customs and Border Protection? Well, if USCIS believes that the information in your application is needed to identify or prosecute a criminal offense, if it is for national security purposes, it's for assistance in the consideration of the DACA request, it meets the requirements for an individual to be placed in removal proceedings, then that's a circumstance where your information from the DACA application might be shared. If you knowingly make a misrepresentation or knowingly fail to disclose facts on your DACA application in an effort to gain the DACA benefit, you will be treated to the fullest extent permitted by law by ICE as an enforcement priority. So they've made a very big statement in terms of DHS saying, if you commit fraud or misrepresentation in your DACA application, we're going to take that seriously and you could be in some serious trouble. That is not to say that if you entered the country on fraudulent documents and you are applying for DACA and otherwise meet all the other eligibility requirements, that doesn't mean that you fall under this category of you are making a misrepresentation or committing fraud in your DACA application and that information is going to be shared with ICE. That's different. Many people that entered without inspection or entered with inspection, arguably, but entered with false documents, that's going to cover a lot of the DACAs, and that's not necessarily a disqualifier or something that's going to get your information shared with ICE. Travel guidelines, just briefly here, we just want to mention that if you traveled before August 15th of 2012, you're going to have to prove that your departure was brief, casual, and innocent. If you travel after August 15th, 2012 and before USCIS grants deferred action, that's going to cause a problem with your continuous residence requirement. So we are going to be recommending to you no travel once we've filed that application and you haven't received your adjudication positively on deferred action. And there's going to be some situations where we are going to recommend that you don't travel at all, because with DACA, if you are approved, you do have the eligibility to file for an advance parole travel document. That doesn't mean that our recommendation is that you should leave the country on that travel document just because USCIS has granted it to you. And why is that? Because most of our DACAs are going to be subject to 3-year, 10-year unlawful presence bars to reentry. Even if you're granted an advance parole document, you have no guarantee, if you present that document upon reentry, that the border officer isn't going to apply the 3-year, 10-year bar for your illegal presence from before and bar you from entering the country. So in many cases, we are taking the cautious approach and telling our clients, wait and see. Let's see how the other government agencies, particularly Customs Border Protection, USCIS, are interpreting the law regarding advance parole and the 3-year, 10-year bars. Thank you so much for tuning in. For more information, please contact IMLAW. We look forward to hearing from you.